I am so pleased to introduce my friend Mark Stevens, art lawyer extraordinaire. He's based in London. He regularly advises the Tate Gallery, private galleries, and artists who include Ai Weiwei, Banksy, and the Turner Prize nominee Phil Collins, whose show opened last week at the Tanya Bonnock Art Gallery. He also represents artist estates, including those of Picasso, Matisse, Miro, and Mapplethorpe, and he has pioneered artist resale royalties in the UK. For his work, the Queen has made him commander of the British Empire. Today, he will tell us about his ongoing representation of the government of Greece in the looting of the Parthenon marbles. And also, he'll introduce us more generally to the ongoing landscape of art disputes. So, Mark, thank you.
Thank you very much, Anne, and thank you for having me here today. Forgive me, if you will, but in order to look at the legal niceties of this particular case, I think we have to go back and look at some of the facts. And if I'm teaching you to suck eggs, I'm sorry about that. Please bear with us, because I suspect some people in the room will need some of the information, which will, I hope, come to a conclusion where you will see the purpose of the points. Of course, the title is deliberately provocative, but of course it's a real problem. Are the Parthenon marbles belonging to Greece? Are they the Elgin marbles? Did he get them legitimately? And are they legitimately in the British Museum in London? And I will come to the question of the bribe over Brexit towards the end of my talk, if I may. So, in essence, Parthenon was built along with some other buildings on the site, temples, 2,500 years ago by the world's first democracy at the instance of Pericles. It's a UNESCO-listed World Heritage Site, unsurprisingly. The removal of partial bits of the Parthenon frieze happened about 200 years ago at the instance of Lord Elgin. He removed 56 panels. He took some pedimental sculptures, and of those, there's about 40 in Greece, 40 bits of the panels in Greece. And of course, many of you will know that the Greeks have built a museum at the foot of the Parthenon Hill to receive all parts of it. It's perhaps also worth saying that various bits have gone to other folks. So there was a head that was broken off in 1687 by the Venetians following an invasion of Greece, and that has now found its way to France. There's two meatopes heads in Copenhagen. So the question really comes to the fore, was Lord Elgin a robber or a saviour of the marbles? The Catchcry, "No Elgin, no marbles," has been uttered by the British establishment for, well, since the mid-1800s. And I'd like to examine the truth of that today. It does also seem to me that we should look at Elgin. Elgin was a Scottish peer. He always wanted to become an English peer, but was never granted that a higher honour. Scots give peerages out, or used to, fairly lightly. They're given more reservedly in England, or certainly were then. And the question that really comes out is that in this Catchcry, "No Elgin, no marbles," it does seem to me that a person who is a crook, who took better care, which is what's the Catchcry is about, a crook who cares carefully for an artwork that they have stolen from a museum doesn't get any better title than the person who stole it. And I will make the case that Elgin was nothing other than a Scottish peer who was a crook. And that is part of the basis on which it should, they should come back to Greece. Perhaps a few more dates for your noting. Greece was illegally occupied in 1458 by the Ottomans, and they basically held custody of the country until 1832, when they got independence. And this is relevant because there are a couple of things. Under the laws of war, there is in international law, and was then, an obligation to respect temples and places of worship and historical and cultural places of historical and cultural significance. And interestingly, going right back even to that time, the Turks and the Ottomans honoured those obligations that they understood that they had in international law. The Venetian invasion, which took place briefly in 1687, again, with the one exception of the head that I spoke of, again, they honoured their obligations to maintain the marbles and the Parthenon intact. Then perhaps worth looking at people who are going on the Grand Tour. Now, people did go regularly on the Grand Tour. In 1780, the French ambassador, interestingly, asked to be able to take sculptures, and he was refused permission to do that. Again, in compliance with this obligation in international law not to effectively deleteriously deal with historical and culturally significant locations. That sort of brings us to 1800. That's the backdrop. So it's 20 years after the French ambassador is refused permission. 1800, Elgins sends some artists to draw images of the Parthenon and around. Interestingly, they're not allowed even to enter the site for the first 6 months that they're there, and they have to make their drawings from Lycabettus Hill on the other side and from further afield. After 6 months, they work out a pragmatic solution, and they give a bribe of £5 a day to be able to go onto the site and to draw and to take images. Interestingly, even with what even in those times must have been a massive amount of money, particularly to the locals, they weren't allowed to do anything other than draw the purposes. So they weren't allowed to have any scaffolding, no carts, all of this. This is all carefully documented at the time. At this time, Elgin is having a new house built called Broom Hall. It's done by the eminent architect Thomas Harrison, who makes the house the grandest thing in the Greek style of the period. And of course, part of the reasons he wants these images of the Parthenon and ancient Greece is to complete and to decorate this house that he's spent a lot of money on. We then get to 1801, and I should say, in 1801, although his artists have been sent down to Greece, Elgin hasn't yet visited the country. He hasn't seen the Parthenon for himself. He hasn't bothered with that. In 1801, we have the Battle of the Nile, where Nelson's ships defeat the French and drive them out of Egypt, which of course returns Egypt to Ottoman rule. So the question then is, what was the law that was applicable at that time in the land that is now Greece, in Athens, which was formerly a city-state, I suppose. And part of that is that it would have been Sharia law, was Sharia law, because the Ottoman ruler was effectively the ultimate administrator of Sharia at that time in that particular part of the world. And in order for something to be done, the Sultan could, if he felt so inclined, grant what was known as a Fermin, F-I-R-M-A-N. And a Fermin is effectively a license, a permission, and it's in the form of a formal decree. And what happened in this case is that there was a request made by the Reverend Philip Hunt for a Fermin. And there was a quite interesting, there was a later select committee investigation into this in Parliament in London, and they actually identified the terms of the permission that was given. And this relies on the evidence of the Reverend Philip Hunt, who was a priest in the employ, in the household of Lord Elgin. And so it says, artists, in translation obviously, artists in the service of the British ambassador, Lord Elgin, should be entitled to enter freely within the walls of the citadel and to draw and model with plaster the ancient temples, there to erect scaffolding and to dig where they may wish to discover ancient foundations, and liberty to take away any sculptures or inscriptions which do not interfere with the works or walls of the citadel. So that doesn't, as you will have clearly understood, give you permission to rip bits of the marbles off the walls and leave them in the Duveen galleries. So that's the only permission that is ever given to Lord Elgin, which is essentially to take the plaster casts of it. And of course, in terms of his house in London, that would have been something which they would have used these artifacts to decorate part of it. In 1816, which is when we got to the point of having this parliamentary select committee, this Reverend Hunt said that the civil governor was, as he put it, given presents of bribes and favours which induced him to give a very broad interpretation to this Fermin that I've just read to you, which allowed the removal of the panels and the other parts that Elgin took away. In the process, they used ropes, chains, saws. They cut up the panels. They cut some of them in half so that they could reduce the weight for transport, and some they just leave it off the wall. They broke much of the Parthenon in the removal of the panels. The artifacts which they took, they shipped down to Piraeus, the port, and in Piraeus they put them on a combination of British military ships and ships specifically chartered by Lord Elgin to return them back to the UK. Well, that's the story insofar as you get it from the Select Committee. But there's also an underlying question of whether the Fermin actually existed at all. And what's interesting is that if you go to the Sultan's archives, there is every other Fermin during this period, but this particular one appears to be missing. And Lord Elgin didn't have a copy, he told Parliament, and the only copy that appears to be in existence was that an Italian translation of the Fermin. Now, history doesn't relate why Reverend Hunt or Lord Elgin, or indeed the Ottomans, would want a translation in Italian when none of them spoke Italian. But apparently this was the circumstances. So I think there is an open question as to whether the permission really did exist in the first place. There was clearly a document, but what that document was and under whose hand and whose authority, given the distance from Constantinople to Athens, I think there's a real question about who had those. But, let's gloss over that for the moment. I've mentioned the fact that there was some fairly significant acts of vandalism in removing the works. But there was another rather gratuitous act of vandalism, which was in 1802 when Elgin finally turned up. To celebrate his arrival, he had his workmen carve both his name and that of his wife into the Parthenon itself, because that's what you do, I suppose, if you're a Scottish peer. Anyway, the other thing that's interesting about this is that Elgin had diplomatic immunity. He was the British ambassador to the Ottoman Empire at the time, and so his thefts would also be protected, and he would have been able, so even if someone at the time had chosen to take action against him, he would have been able to plead diplomatic immunity. And that, I think, feeds into this general background and the scheme of how we have to analyse this in terms of the law. Elgin returned home in 1807. He was, by this time, nearly bankrupt. He was syphilitic to such a degree that his nose was gone. His wife divorced him for the reason that he had this disease of the day. He'd been held on his return from Greece between 1803 and 1806, a prisoner by Napoleon, and had got away on giving a bond and promising to return when he was required. And really until Waterloo, he was running scared of Napoleon coming after him. He'd lost his Scottish peerage at this point. He, because of what he'd done in Greece, had become something of a scandal in London, and he was suffering the opprobrium of British society, and there's nothing worse than being frozen out of British society, as you'll know. So it is with Elgin. He then decided to write a book to try and rehabilitate his reputation. And he did it anonymously and published in 1810 a book called The Memorandum on the Subject of the Earl of Elgin's, although he wasn't an earl by then, Earl of Elgin's Pursuits in Greece. And at the same time as he put out this propaganda pamphlet, he offered to the Prime Minister of the day and the Paymaster General his sculptures for the sum of £70,000 plus an English peerage. Obviously, the English peerage was important to him. the government counter-offered £30,000 and no peerage. He refused. This then went a bit quiet from about 1810 through to 1816, when he petitioned Parliament to form a select committee to see whether the government should acquire the Parthenon marbles. And although the select committee is partly about value, it's also partly about whether he has title, because this is already a scandal of the period. We forget, with the propaganda that's been put about that in more recent times, that at the time he was regarded as something of a bad actor, and the government was even concerned with doing a deal with him at this particular point in time. Well, the upshot of the select committee was that they recommended acquisition of the works for £35,000. That decision was adopted by a vote of 82 to 30, so you'll see it was not an uncontroversial vote. And they were then passed by the British government, who paid the £35,000, which kind of dug him out of the financial hole that he was in. They gave the works to the British Museum trustees in perpetuity. So that's the background, and I hope you'll forgive me for taking time to go through it. But that leads me to a number of legal questions. And so the first is, what title did Lord Elgin have? It's trite law that you get no better title when you buy something or you acquire something than the person who you got it from. So if Lord Elgin stole the marbles or acquired them through corruption, he didn't lawfully acquire them in the first place. No title can have gone to him. They were not his to sell, and as a consequence of that, he cannot pass good title to either the British government or thence to the British Museum. As the ambassador, his actions can involve the state. So because he's the ambassador, his actions can be deemed in international law as the actions of the state, whether or not the state knows and approves. And of course, at that time, they clearly didn't know contemporaneously, but they knew pretty soon afterwards, because there was a scandal that came up and around it. The third point, I suppose, is that the Ottoman state, being in unlawful occupation, didn't have authority to alienate the works. And there's a very good book which I would commend to you by Janet Greenfield, Cambridge University Press, which talks about the strong presumption in international law against state divestment, so a country divesting cultural assets. And so, you know, they didn't have, and, you know, it goes back to the point that I made right at the very beginning, this obligation under periods of war and also occupation, that you have to respect the cultural property of another state. In any event, any express authority from the Ottomans in the form of the Fermin didn't, I think it's clear, it didn't cover what was done by Elgin. And probably the last point that feeds into this is that bribes are invariably a hallmark of iniquity. Maybe trite thing to say, but if you've had to bribe someone to get it, you probably don't get legal title to it. So that was perhaps the last point we need to feed into that. We've had so we've got that in international law. So now let's just look at our domestic law. we have a thing called the British Museum Act from 1963. Section 4 allows us to make loans of works, but trustees are absolutely precluded under Section 3.1 from deaccessioning any work unless it is determined to be, quote, unfit to be retained in the collection. Now, the purpose of this is to be able to remove fakes from the collection, but has never been extended to include works which are inappropriately acquired by, say, stolen goods, looted art, has never been part of that. The British Museum has acted as the owner of these since they've been in their possession. They've been to Russia without love. In 2014, they went to the Hermitage. They went to Iran in 2010, where President Ahmadinejad had his hoods stand next to them and made great propaganda about them. So the British have used them as a for cultural diplomacy, for soft diplomacy, but they won't loan them to the Greeks, and they won't return them to the Greeks. The Greeks have sought, as they're entitled to do, mediation by or via UNESCO, and the British government and the trustees have rebuffed that. There's also a process that we have in the UK called the Spoliation Advisory Board, which is that it was developed to allow disputes over looted works, predominantly from the Second World War was the reason that it started, Nazi looted work. But they have refused to engage in an independent evaluation of the title and the right to remove them. And the Greeks have been making pretty consistent demands for the works for a long, long time. And indeed, going back to just after the Second World War, I think there was a little quote from a Foreign Office who commissioned an expert opinion in January 1941. They said the Greeks regard, this is the British government, Lord Elgin's actions as spoliation of their national heritage under Turkish tyranny. The point is that the Acropolis of Athens is the greatest national monument of Greece, and that the buildings to which the marbles belonged are still standing or have been rebuilt. The return of the marbles would gratify the Greek sentiment. And that was the view of the British government. But, of course, in 1941, they had other things on their mind. They were also concerned about a floodgates argument, and this is perhaps something that we can discuss. But it does seem to me that there are fears amongst museum holders, and you see it here with the reluctance to return Native American indigenous artifacts to the relevant peoples. So it is that you see the same in the UK. It is fair to say that there are no time bars. There's no statute of limitations for a claim of this kind. And that's because this is an interstate claim. It's a claim between two states. Of course, you could take legal remedies. You could go to the Greek courts and get a declaration that they should be returned. But I think most of us would think, practically, the likelihood of that being complied with by the British government would be low. You can go to the International Court of Justice, which again is geared up to deal with interstate claims. Or you can go to the European Court of Human Rights, because these are property which can be returned, and they can make that declaration. There's some really interesting precedents out there for an International Court of Justice claim. So, for example, there was a case in 1962 between Thailand and Cambodia when the Temple of Preah Vihear, and the question was it a Thai or Cambodian cultural artifact, was found in favour of Cambodia, and it found that the Thais had illegally removed things, so they were returned. There was a very interesting case in Italy. Venus of Serini, a sculpture, was taken from Libya to Italy in 1913, and a case came up in 2008 in Rome, and the Rome court made the determination that the work should be returned on the grounds that nations cannot, in international law, take cultural items from one country to another as a result of their cultural domination. And so again, we're getting this theme coming through from international law. There's in international law the UNESCO Convention from 1970. There's a Vienna Convention from 1983. There's a very interesting case. I'm scattering over this because I want us to get to a point of a conversation in a moment. Webb against Ireland, where some 9th century valuable materials were, ecclesiastical materials were disputed, and it was determined that Ireland, even though it didn't exist as a state at that time, owned the cultural objects which had been found there. More recently, a case called Iran against Barakat Galleries, which cited the Webb and Ireland case with approval, returned to Iran, again a country which didn't exist 4,000 to 5,000 years after the treasures were created, those kinds of works. And we've also seen cases arising in northern Cyprus, which was illegally occupied by a Turkish invasion, and yet another Turkish invasion, where the Greek Orthodox Church lost a lot of both mosaics and also icons, which came up on the market. And there was a case here in Indiana, the Supreme Court of Indiana, back in 1990, where essentially the work had to be returned to the Greek Orthodox Church. So we had this issue which really comes back to cultural property in a time of war, and there was some very interesting things. The first jurist to talk about this goes back as far as 1758 in a jurist called Vettel, who wrote in the Law of Nations, for whatever reason, a belligerent plunderer of countries, he should spare buildings that are the pride of mankind and do not strengthen the enemy, such as temples, tombstones, public buildings, and all other works of art distinguished for their beauty. Now, this is again, I think, quite interesting, because it goes back to the fact that there were these obligations in law. In 1812, we were at war with you. There was a little local difficulty. There was a ship that was captured, an American vessel, on the high seas, and a petition was presented because the cargo was a cargo of paintings from Italy bound for the Philadelphia Academy of Sciences and Art. And the British Admiralty Court, sitting in Nova Scotia, determined that because these were objects of artistic value, they should be returned, even in a time of war, to America, and indeed that's what happened. So there's some very interesting history here in relation to that. We've seen other cases around the world, particularly around, so I spoke briefly with Anne before we came about a case I did a few years ago about Tasmanian Aboriginal remains, which were held in the Natural History Museum in London. And they were obtained illegally. They were partly, there were 13 individuals. They were partly the subject of grave robbery, partly the subject of massacres. The British government described it as a genocide in what was then Van Diemen's Land. And in the context of the period, with Darwin writing his book, it was thought that this isolated Aboriginal community were part of the evolutionary or evolution, and that these individuals, these Aboriginal individuals in this isolated community in Tasmania, were just a lower version of us on the evolutionary scale. And so people literally shot, executed them because they were seen as subhuman, and their bodies were boiled down, and their heads and other parts of their remains were kept as curios. And indeed, the British had a cultural power at the time, and they were called the protector of the Aboriginals, and their purpose was to protect the interests of the Aboriginals. And of course, they did absolutely no such thing. And there are many pictures of the protector's house where he and his wife kept little piles of skulls, rather mawkishly really, on the mantelpiece in their home in Tasmania, and then later brought them back to London to show their friends as talking pieces. And this was fairly common at the time. And this resulted in this case because in the Aboriginal tradition, their belief system is that they can't enter the dreaming, their version of heaven, until their olds, their ancestors, are buried in their own lands. And so returning the remains of these 13 Aboriginal people to their homeland was significantly important to the life and belief system of the living Aboriginals in Tasmania today. And it was quite humbling to have a case where my client, who was an Aboriginal leader, stepped forward and spoke very, very movingly, with tears rolling down his cheeks, about his belief system and what he felt would happen to him in the event that these bodies were not returned, or these remains were not returned for interment in Tasmania. So I really wanted to talk about those kinds of things. I suppose the only other issue that might be relevant in terms of legal perspective, in terms of the historic cases involving Aboriginals, is the recognition that they are a minority. And as a minority, they're protected in international law, they're protected by the Australian Constitution, their special position in society is recognised in their domestic legislation, in the Aboriginal and Torres Strait Islanders Heritage Protection Acts, Aboriginal Lands Acts. There's a case called Mabo, which is about Indigenous people's lands in Australia. And there are similar cases in relation to New Zealand Maoris. And some of you may be familiar with the case where Phillips, the auctioneers, tried to sell a Maori head and were precluded from doing so and had to return it to the tribe from whom it originally came. So I don't know whether I should sort of stop there and open it up and see whether there's any comments, questions.
Well, let me suggest that you tell us about the Brexit bribe.
Oh, all right. Yes, that would be a good one, wouldn't it? Yeah, since it was in the title. Yes, all right. Sorry, I missed that. I've talked about the court cases that are potentially there for the Greek government to be able to initiate, should they wish to. But what has happened is that Realpolitik has kind of interceded. We are now in this process of Brexit where we are negotiating for the terms of our separation from the European Union. And two things have to happen. The negotiating teams have to agree a suite of terms, and then it has to be put to our Parliament, and it has to be put to the 27 parliaments of the other European Union members. In fact, it just happens to be more than 27 because it also has to go to the parliaments of Belgium, which of course is Walloon and French, so they've got two, and there's a couple of others that have got a couple as well. So there's rather a lot, what is going to need to happen is that we in Britain are going to need to find significant reasons for these countries to vote for whatever deal it is to do it. And the Greeks have made it clear that they are expecting, as part of their consent, that the return of the Parthenon marbles to the museum should be part and parcel of procuring their consent. So these marbles, which are, as we see here in the Duveen Gallery in the British Museum in London, are likely to become a political football in the next 18 months. So that...
We'll take questions on just about anything, correct?
Yeah.
Does the consent, does it have to be unanimous consent of the members of the European Union?
Yes. So each country separately has to agree, and if they have more than one parliament, they each have to agree. I don't know whether you're familiar with the trade agreement which recently the European Union agreed with Canada. It was derailed by the Walloon Parliament deciding that it didn't like it. Didn't have sufficient in there for the Walloon community, and as a consequence there was a fair bit of cajoling, presence and beating up of them, and eventually they did have a second vote and they passed it, so, but not without problem. No, the Walloons are the Flemish. Yeah.
When was it? I mean, the Parthenon was fairly whole for 2,000 years before someone naughty, was it Napoleon, stored gunpowder in it. And after 2,000 years, the roof was blown off. And was it Napoleon? And did Elgin find a rather perfect Parthenon or a post-explosion roofless Parthenon when he decided to collect?
I don't. The question is, was the Parthenon roofed or unroofed at the time?
Or was it was it destroyed when he? When was it destroyed?
The answer is that Elgin conducted the initial supreme part of the vandalism of the Parthenon. There had been a number of things that had happened. I referred
what
to
was that calamity?
I don't remember the date.
1687.
Sorry?
1687.
Oh, so
There
it
you
was
go.
a ruin A gunpowder motor, really.
It was
It's just
blown
the
up.
incident was that.
So there was quite a lot of it though, but the rest of it was still there. The friezes were all there, and so as a consequence of that, it was still regarded, and it was being regarded at that time by the Ottomans as being a cultural icon which needed to be preserved. And you can see that their behaviours, and indeed those of the Venetians, apart from this one head, headlet meotope, is actually respected. And it's very interesting that a fair bit of it is there. It's the Western cultural imperialists that actually pay very scant regard to this this building and cultural heritage.
Well, didn't the Venetians lob a shell into the Parthenon, and that's what blew it up because the Turks had stored ammunition inside the building?
It was being used as a strategic location, but interestingly, when it was taken, because there was one battle when the Venetians went in, and another battle when the Turks retook it. And in both cases, the commanders gave instructions to their armies not to target the Parthenon itself. So even, military folk at that time were recognizing that this was a place of cultural heritage. Now, the explosions and things I'm less clear of. Yeah?
I have a question about the Fermin.
Yeah.
That was pretty fascinating that in the Ottoman archives, that particular one doesn't exist, and that we only have it in an Italian translation. And I have two questions. One is, where was the Italian translation found actually? And the second question is a legal one. What would an international court make of the discrepancy, and would this Italian translation be considered an actual piece of evidence?
Well, it's a really good question, and thank you for asking it. The answer to it is that the Select Committee had such regard for the Reverend Hunt that he was the one giving evidence, and he said that he had a copy of this in Italian at home. They didn't ask why, and they didn't ask him to go and get it or send them a copy. So he then recounts, and I read you the transcript from Hansard. He recounts what his best recollection is. But his best recollection isn't good enough to get Elgin home. And so, I think that there was clearly a document that was being waved around at the time, and I think shown to local officials. And I think it was probably, if you look at the background material, and this is a bit, it starts, as you start to go off-piste here, things start to get a little hazy. But in the background, you have a senior governor in Constantinople who is indebted to the British for help in Egypt, and also wants his son to learn military activities in England. And so he writes a letter which says, please give all assistance and all the rest of it. It is not a Fermin. It is a letter, it's an exhortation, if you will, to do all that you can within the law. But of course what we have also determined is it wasn't in the law that you could do this. So it may be that this letter, together with the bribes, was what truly is what actually allowed people to do it. But it is also clear that the bribes, which were pretty large, wouldn't have, the works wouldn't have been allowed to be removed but for that. So again, the Fermin, I think, I personally don't believe it ever existed, and I think the Reverend Hunt lied, and there was no sort of questioning about why there was this Italian translation, and there's no logical reason that I can see, and if anyone's got one, I'd be good to hear it. But I can't see why he would have kept it, particularly because he couldn't speak Italian. So how he'd know what it said seemed to me a fairly fundamental flaw in his story. And of course he was involved in this. He was the person who'd gone to Greece and negotiated with the locals. He paid the bribes on behalf of Elgin. So he was effectively Elgin's man on the ground. And again, you know, look at that in the context of this scandal that had occurred, and I think he hadn't anticipated that. When he gets back to London, he's also trying to rehabilitate his own reputation, and who knows whether he was in for a slice of the action from Elgin if he got a bit of money.
And part two of Professor Berlin's question is European Court of Human Rights, perhaps.
Yeah. I think the way in which an international court would look at it is that they would make a judgment about what they thought was the likelihood that a Fermin actually existed. I think that how they would inform themselves is that they might come down and say, on balance, we can't come to a conclusion about that, but what we can do is read the terms of what Hunt said the Fermin was, which is effectively the high point of Elgin's case. And on that basis, it's obvious that, you know, he didn't get title and he wasn't entitled to take them away. He was entitled to do drawings and plaster casts, but he wasn't entitled to dismantle the place. Yeah.
Is there a distinction, a clear distinction made in law or otherwise between freestanding statuary and architectural sculpture?
No, provided that they are, I mean, I've used the Parthenon marbles in a loose term. I'm not sure that I intended to say at the beginning that I did actually mean to include some of the other sculptures which were taken from the site. There's another building which had 5 statues at the front. Elgin took one, presumably because he needed something to prop up his front door, and he didn't need 2. And and there were other pieces that were taken from around the site and from other buildings, lesser buildings on the site. But you know, it was all being protected at the time, and I think, you know, it goes back to this Catchcry. I think that at the end of the day, it was being protected, and there was no reason for Elgin to take them, other than he wanted them for this Greek house of his. He didn't want them for the British government. He sold them under, in effectively, a forced sale because he'd run out of cash. So there was no, you know, there was no other good reason to do it, and everybody had been preserving them, as you say, for 2,000 years or more. And so I think that they would have survived even through the Nazi occupation.
But shouldn't there be a distinction for sculpture that is specifically made for architecture, belongs to that architecture?
Yeah, I mean, the analogy that you would make, I think, is a more modern notion, which is about site-specific work.
Mm-hmm.
Yeah, I mean, so, you know, artists create work for a specific environment. Right. And I can see how, you know, if you've got something which is site-specific, but what does that mean in law? It doesn't mean that it's, in artistic terms, it ceases to be an artwork if you remove it from the environment for which it was intended. And there was a Richard Serra sculpture here where they took it down and they tried to move it, and Richard said, no, that was site-specific, it was intended for that particular location only, and it ceases to be an artwork if it's moved. I don't think people can compare the same with statuary. Yes, they were site-specific, but they don't cease to be cultural objects. They cease to be perhaps artworks and relevant to their context if they're removed. But the artist isn't around to make that argument at this time. So I'm not sure that legally we can make a different point. I mean, it's a good thought. Yeah.
So you were representing the Greek government, and you are no longer representing the Greek government. Is that correct?
Yeah.
Regarding the Parthenon marbles.
Yeah.
And I was wondering why the Greek government has now stepped back and sort of
I'm not in a position to answer that question.
You're not.
But thank you for asking.
I'm wondering whether this Brexit bribe idea is their new focus, or whether or not they are still planning to pursue these other avenues in order to get these back.
I don't have an insight into their current thinking beyond that which I've articulated.
So when did you cease being the
I
representative?
feel I'm being cross-examined.
When did you cease representing Greece in this case?
It was a couple of years ago. You can date it by Amal Clooney's wedding. It was about a month after Amal Clooney's wedding.
What would you like to see happen?
Personally, I'd like to see them go back. I think that they do need to be returned. I think that it's a shameful part of our history. I mean, I haven't talked about the custody, and so Duveen had them cleaned with wire brushes, and so the paintings, because they were painted, and the patina of age was all removed to get it to a bright, sparkly white. Duveen washes whiter, and even the British thought that was appalling, but it was just kind of hushed up at the time. So they aren't as they were, but I think that there's a museum for them. It seems right to see them in that cultural context. But there is a question, which I think is troubling the British Museum trustees, about how do they return these, and they know that they've got a lot of other nicked stuff, and so how do they draw the line? And one of the things I had this problem with the Natural History Museum over the Aboriginal remains, and I said, well, the line that you draw is if there is a living belief system which affects people today, perhaps that's a line that you can draw so that you can return these. And the Natural History Museum eventually were persuaded, the trustees, to accept that. A bit reluctantly, had to be said. But the question here, I think, is a slightly different one, because there's no belief system that's relevant. And I think that what one has to do is say there's a hierarchy of cultural and historical artifacts, and some go to the very visceral parts of a nation's nationhood, or a people, or a culture. And I think you'd be difficult to argue that that doesn't happen with the Parthenon. I think you have the same issue with Tutankhamun, and there are things that reach that level, but I don't think it's everything. And so I think that there is a reasonable line, and you could take UNESCO World Heritage as a kind of a benchmark for these things, as a way of identifying those indicia of works of cultural items which are relevant. And I can't think of a better way, but if others I'd be really interested to hear any thoughts you've got on it.
Remember the Martin Steinach case, about the piece that was the Indian sculpture that was taken away from
Thailand?
not-
Cambodia?
No, it was India, and it was meant to be restored, and then somebody actually substituted a fake piece, and eventually, what they eventually did was work out an agreement with the Indian government that the statue would be returned, that the Indians wouldn't make any claim on other Indian sculptures that he had, and that it could be kept on view in the museum for a certain number of years. So it seemed to work out well.
Yeah, and I think those kind of practical solutions are potentially doable. So, for example, the Greeks did offer the British Museum to give them the Parthenon marbles on permanent loan, to put them in the museum, almost to make the new Parthenon Museum a branch office of the British Museum. And that surmounted two hurdles. One, the sort of feeling that we were giving something up, but also the question of deaccessioning, this statutory bar about removing things from a collection. So it was a way of surmounting.
But you just they offered, Greece has offered the Elgin marbles.
Yes, there was
in London, in Brooklyn.
No. They would be on permanent loan in Athens.
Okay.
From the British Museum in London, but the British Museum trustees declined that, and they have refused ever to let them go to Greece because they fear that the Greeks will nip into court and get an order restraining their return.
Where would you place the Nefertiti bust, for example, on that sliding scale of importance that you just illustrated for Egypt?
I haven't thought about it. Where would you put it?
Well, the Egyptians put it pretty high. It's on their top 5
Right.
of objects that they're trying to get back. I would put it pretty high. It's very recognizable as a cultural object from Egypt.
Yeah, I suspect. I wonder whether. Whilst I understand why they'd want it, it's very beautiful. I just wonder whether it is something which you can say was so identifiable with Egyptian culture. I'm a lawyer, I'd make either argument, I do think there is a question about whether that achieves that level of cultural identity that something like the Parthenon or the pyramids or the contents of the pyramids do. And so I think that perhaps is an issue, and maybe I argue against myself because it's something that come from those things. So forgive me for thinking about it as I go, but I think it's a very interesting question. If you look at some of the things which have been argued to be returned, they aren't issues which go. So if you think about the ecclesiastical find in Ireland, that wasn't particularly, focused on the country. So the law is far more elastic. What I think I'm trying to do is to find a benchmark which wouldn't denude and empty every museum in the world. Although if you look at the UNESCO resolutions on these things and what is supposed to happen, basically it's supposed to go back. I think it is slightly imperious and imperialistic to say, well, you're not capable of looking after it, because by and large that's not true.
You have time for one more question, Aaron.
This is one of those kinds of comments that's kind of a question. So because you raised the kind of indigenous analog situation, while it was the case 20 years ago when NAGPRA was first passed, the mandate repatriation within the United States, this sort of museums worried about the floodgates opening and tribes rushing in and saying, give us all our stuff back. That hasn't happened for various interesting reasons. In many cases because tribes don't want stuff back. In some cases because they want stuff in the museums to represent them to the world. I recently took my class at the Metropolitan Museum and we talked about the Benin bronzes. And the curator said that the current Oba Benin has been to the museum in recent years and said, we want these to stay here because we want our cultural heritage represented in the Metropolitan Museum. That's a certain kind of argument. So the floodgate argument hasn't panned out. I think that's not, I don't know that it would pan out internationally in different ways than it's panned out in indigenous cases. Just another anecdote is that I work with a tribe in British Columbia who have successfully gotten an object on long-term loan from the British Museum. And their argument was not that it was absolutely essential to their cultural identity, but that it was stolen by the Canadian government from them, and they have been very selective about their repatriation claims. They have said, if we need objects to dance with, we'll make them. We want the things back that were stolen from us under colonial law. Were actually stolen from us outside of colonial law, even though we're illegal appropriations. And so in that, and they negotiated this long-term loan, and last year the British Museum called it back to London to make sure that the trustees know it's still owned by the British Museum. And then it will go back to the community. And shortly after the director of the Cultural Center negotiated this, she was flown to Greece and talked to them. So it's interesting to me the way in which, in some cases, the indigenous model is held up as a parallel, and ways in which it's not, right? So you said it's not because they have a kind of minority status, which we could say Greece doesn't, but this kind of anxiety about, the emptying out our museums.
I tend to agree with you on the floodgates argument. I think that, actually finding someone who you'd have to give these things back to. There was a period where American indigenous folk were making claims, and I know that, for example, the Ford had a policy of hoping that they get competing claims so that they could just sit on them and say, well, when you guys have sorted it all out, we'll hand it over to whoever, which I thought was a little cynical. But I think that the problem you've got is that the understanding of the general community, and particularly of trustees of museums, is evolving. I think that museums are very worried that philanthropy will drop off in the event that they are thought that things are going to be disappearing from their collections, so people are not going to want to support them philanthropically. So I think there are issues around it, and I suspect we're on a journey here, and I am sure that at some point the Parthenon marbles will return to Greece. I'm just not sure what that time frame is going to be. The other thing is that I think in relation to human remains, one of the things that I didn't allude to, which I will share with you, because Anne used to deal a lot with dead people in her practice, mainly because they didn't argue about their bills, was that I pulled a little bit of a fast one, which is that I had the only remaining descendants, the Tasmanian Aboriginal Centre, which is made up of Indigenous Tasmanians, made the administrator of the estates of these 13 humans, and then I, under the Colonial Probates Act, registered that letters of administration in London. And so by the time the Natural History Museum found out about this, we had the right, the legal right, indeed the obligation, to collect in the remains and to dispose of them properly for burial. That's part of the duties of an administrator. And that gave us, interestingly, in law, a better obligation and a better title to these remains than anyone else. So there are not direct parallels, as you correctly identify, but I think the way in which museums are processing these claims is also quite interesting, because we're seeing, I think, just about every human remains case for Aboriginals and Maoris have been returned. The last sort of laggards were the Pitt Rivers Museum, and they've allowed theirs to go back now. So I think there's a standard which accepts that human remains should go back. So where we go next, it's got to be the cultural icons, I think.
Thank you so much. Join me.